Well, hello again, and welcome to the fourth of the 4 parts on this seminar on boundary evidence, ancient footsteps, and state-of-the-art technology. And for the benefit of those who may not have seen the previous 3 sessions, I'm going to go ahead and read the overall description of the seminar, what it means for all 4 of them together. It says here the charge to the land surveyor has always been identified with the location or determination of corners of land parcels. Even though the equipment and methods used for field measurements has significantly changed as a result of advancing technology, the stated charge to the land surveyor remains the same. This seminar will examine how the 21st century land surveyor, while measuring with such high precision, can be no more accurate than the original surveyor whose footsteps that he or she is following. And additionally, the benefit of the proper application of theory of location and written surveyor reports will be discussed. And I've mentioned in the other 3, and I'm going to mention it here, that it was the intent that those of you that are attending get the appropriate continuing education or professional development credits for your attendance, and that would work in both Indiana and Illinois. So with that, here's the 4th of 4 50-minute sessions on the topic of boundary evidence. And this one is titled Written Surveyor Reports. This session description reads that some states, including Indiana, require written surveyor reports to be included with boundary survey plats. In addition to providing a method to explain the theory of location used to determine the boundary corners, the reports also allow for statements of uncertainty relative to found monumentation, lines of occupation, conflicts with adjoining parcel descriptions, as well as the precision of measurements. As I look back on the time that surveyor reports were beginning to be required, I remember much mumbling and grumbling of fellow surveyors. For those of you that were in the session we just completed on theory of location, we were about the same time here. Surveyor reports were in that initial release, if you will, of the standards that became Rule 12. Fortunately, some of the surveyors that I spoke most often with, while being reserved about the topic, were not as negative about this new requirement as others. I heard one fellow surveyor put it this way. He says, well, why don't we look at it, and rather than looking at it as a rule from the board, which we always tend, as humans, we always tend to get a little bit upset when somebody above us is starting to tell us we got to do something else. He said, what if I said here, and we were at the recorder's office, or I don't know, maybe we were at a local chapter meeting of our state society and talking in the bar. I don't know where we were, and he says, what if John Smith, and then say John Smith was a local surveyor, what if John Smith puts a survey plat out, and I show it to you, and I say, look, he in addition to showing the drawing and the way we typically show what we do out there and stuff like that, look what he did over here. He wrote it's like a narrative. He's got some paragraphs, and he's talking about why he did what he did and what he based his survey on, and there's some points out there that didn't fit, and he's explaining that and all. And he said, I think that's kind of cool. What do you think? And I'd probably look at that and say, wow, I bet the public and the courts and the title companies and a lot of others would really, really gain some value out of reading that, because it's going to let them know what this drawing or this picture is all about. And I kind of took that guy's explanation, and I used it with many other surveyors to try to spread the word, if you will. And even in my classes, I talked about this when we get involved in surveyor reports and talking about what they were. And although it's more of a common theme today with surveyors in Indiana, it's still some need to understand why they're there. And I do got to say, as a licensed surveyor in Illinois, now I haven't done very many Illinois boundary surveys lately, But when I do a survey in Illinois, I still prepare a surveyor report, even though it's not required. I think it adds a lot of value to the, if I can call it a product. So let's get into the Rule 12 again. And in 865 IAC 1-12-12, it's in section 12, they're talking about the publication of retracement survey results. Now, I don't know if there's a misprint here, and if this is in there a second time, I can't remember, because there's been changes to Rule 12 over the years, but there used to be separate sections for original survey results and separate section for retracement results. But we're not going to have something up here about original surveys. But if I were you and you're wondering when you need to do these, don't look at this and think you only use it for retracement surveys. I would put a surveyor report together for an original survey also. But here it says, when conducting a retracement survey, and I have on my paper, I put in, or an original survey, a registered land surveyor shall do the following. Number one, furnish the client with a written surveyor's report that, in addition to other pertinent data, identifies the type of survey, explains the theory of location applied in establishing or retracing the lines and corners of the surveyed parcel, and we talked about that in the last session with theory of location, and gives the registered land surveyor's opinion, professional opinion, of the cause and the amount of uncertainty in those lines and corners because of the following. And there's 4 areas that we need to get into and address. First is the availability and condition of referenced monuments. Second, occupation and possession lines. Third, clarity or ambiguity of the record description used and of adjoiner's descriptions, and the relationship of the lines of the subject tract with adjoiner's lines. And then D, or fourth, the theoretical uncertainty of the measurements. So we've talked about a lot of these terms over the last 3 sessions that preceded this last session here. The reference monuments and things like that, any surveying session, we seem to talk about monuments. So that should be very familiar to you. And we talked a lot about that. And with the project that I've been carrying through here, and you're going to see that project that I've talked about come up here at the end of this one too. Occupation or possession lines. We haven't talked a lot about that. We're going to get into that a little bit here. We know that we show those. We have to show those. Old survey plats, if you go back several decades before we had standards, they didn't necessarily show them. They would show if it was a rectangular lot, you'd have a rectangular shape with 4 balls drawn in the corner. Didn't even say what you set. You can picture those with some dimensions on there, and that's it. Legal description, signature, stamp, and that was a boundary survey. Now there's a lot more detail to it. The occupation possession lines. Is that fence over the line? Is it one way or the other? Is there encroachments of buildings? Is there other forms of occupation or possession? Clarity or ambiguity of record descriptions used and of adjoiner's descriptions, and the relationship of the lines of the subject tract with adjoiner's lines. I remember teaching a course probably, well, I've been doing online courses now for 15 or 16 years, so it was before that. So we're probably going back somewhere around 18, 19, 20 years ago. And I was teaching somewhat of a legal course at the campus in Hammond that I was at, the Purdue campus. It was a night class, and we had a whole bunch of students, and a lot of them were from Illinois. I had a lot of folks when I first started teaching these courses, since we were so close to Chicago area there, we had a lot of Illinois students. And one of the guys came up to me afterwards, and I had shown them a plat, and he looked at me and he's got this frowned look on his face, and he says, what's all this? And he's showing how I listed where the what the deed reference was or whatever to the lot next door or all the way around it. And I says, well, we have to do that. That's part of the rule. Oh, we don't do that in Illinois. I says, okay, well, right now you're in Indiana. And I don't know if that mattered to him or not, but he was really rather perplexed by that, because he was in a company that his dad was elderly at that point, but he was still with the company, and they'd been around a long time, and they did things the way that you saw a lot of surveyors do things back in the day. But he learned something there, and he wanted to become an Indiana surveyor. And I kind of lost track of him after he finished school with me. And I don't know if he ever made it or not, but it's important that we look at the description next door. Now, if it's lot 1 and lot 2 and lot 3, and they got lot 2 and you got lot 1, there's not a conflict there. But if they're described by meets and bounds or some other form, and they might have overlaps or gaps, that's got to be called out. And then the theoretical uncertainty of the measurements. We talked about that in the session when we got involved in the math involved with this. And it says here, though, I got off on a tangent here. Well, I guess I covered them all. Okay, we're good to go. Regarding surveyor reports, first off, we can ask a question, why are they necessary? And we'll talk about that. Next, we could ask, what purpose do surveyor reports serve? What's the benefits from surveyor reports? That might be a little bit redundant, but they can also have some separate meanings there. Who are the surveyor reports written to? I'm going to give you my list, and I always get disagreement if I'm in a live room. I don't think I'll get disagreement today since I wouldn't be able to hear you, but nevertheless, I have my opinion on that. What format, if any, is required? And then we get to why. Well, let's go then and get into that. Why are surveyor reports necessary? And I've got my screen beam guy here saying because Rule 12 says so. Sounds like a sarcastic statement. Many surveyors in Indiana asked this question for a long time. We weren't required to write surveyor reports until this new big rule came out, administrative code, so it was law. And the Board of Registration said if you didn't follow it, you're going to have to come down and talk to us. When I note, because Rule 12 says so, it is not too far from the truth. It was a firm requirement, and those who did not comply, as I said, would likely have to go meet with the Board of Registration. The Indiana Society of Professional Land Surveyors played a big role in sponsoring a continuing sequence of seminars across the state to talk about the requirement and talk about the rule in general, and to reinforce the benefits of surveyor reports. I remember starting to get involved in those. That was when I was early in getting into seminar presentation, and I gave seminars on Rule 12 and specifically talked about surveyor reports. And local chapter meetings would include discussion sessions with reports, surveyor reports, that individuals were invited to bring in their plat and the report that accompanies it. And several of the chapter members would bring these in and show how they were complying. And then we would talk without, getting in arguments. There's polite ways of saying, well, I wouldn't do it that way. I would do it this way. And that doesn't mean that either one is only right and the other one is wrong. Before long, the requirement really became accepted as a part of the product of a boundary survey. And before I leave this topic right here in this particular question, I want to go back to another encounter I had with an older surveyor, a very well-known surveyor in the area that I surveyed in. And their office had been around longer than any other surveying company in the area. And he was a second generation engineer and surveyor. And they were known for good work. They were known as good surveyors there. But he didn't like the surveyor report business, and he didn't like a lot of other things in Rule 12. And we had conversations about it, and they were friendly conversations. I didn't ever chastise them for not doing it. I still liked his surveys because usually whatever you found out there worked with other things around it. But I remember one day walking in, and they had a ton of records, and they were always free to let surveyors stop by or call and come by and look through their records to see what they can find that'll help them with their surveys. And they were very open to that. And as I was leaving, I had some students that had worked for him, and he always called me Teach. He says, hey, come here, Teach, I got to talk to you about something. And he usually was telling me stories about old surveyors. But here on this one, he says, I was thinking about this surveyor report thing. And he knew that I knew that he wasn't using them. He says, I was talking to the guys about it, and he says, we put all these notes on why we did this, why we did that, how come we held this, why didn't we hold that, and we put those notes in the file. He says, I guess that if you just think about it, a surveyor report, we're just going to take them out of the file or what we're going to put in the file and add it to the plat too. And he looked at me and smiled, and he says, I think that's a good thing. And from that point forward, they wrote surveyor reports. I'm not taking credit for it. I was glad that I heard him say that, though, because I really didn't want to see such a good surveyor get his hand slapped because of not following the rule. As far as previous requirements, I found this by accident really many, many years ago. This is from the second edition of Boundary Control and Legal Principles. So you're going back, as you can see here, what's talked about here goes back to 1964. It says the California Council of Civil Engineers and Land Surveyors in 1964 adopted the following survey standards for cadastral retracement surveys and surveys based on record documents. And in Part 2A, for procedural and technical standards, item E said that the surveyor will, and item 1 said, prepare a plat showing the results of the survey, and when appropriate, didn't say always, but said when appropriate, the plat shall be accompanied by a written report. And obviously the emphasis there in red is mine. And I was really taken by that. I don't remember if someone pointed me to that or if I read it in POB magazine or what, but I was really taken by that. So the concept of doing surveyor reports didn't start with Rule 12 in Indiana. And also, the one source that I've cited the most in these 4 sessions here was Evidence and Procedures for Boundary Location, 6th edition. And they have in Appendix A of that text article called the Surveyor's Report. And it is significantly different than what we're going to see here with what we do with surveyor reports and the mandate for it in Rule 12, but it's a template for a surveyor's report. I don't know if there was a date on it. I didn't go back and look at the older editions of the book to see if it was in there, but I caught it as I was preparing for this session. And I just copied what it said at the beginning there. It says this document, the document in this appendix is a suggested outline for a report of survey that the professional should prepare to preserve information and to provide the client with an analysis of the work performed. It is suggested that such a report be prepared for each utility survey, but that with a forensic survey, it be prepared at the request of the attorney. We'd have to read into that to see why they would say something like that. I could understand if a forensic survey might have something to do with accident situations or whatever, that maybe the attorney wouldn't want a report to go public. But anyway, the surveyor should provide the client with a copy of the report, but the surveyor should also place a copy in the project files. So this is more of a suggestion, obviously. Evidence and Procedures for Boundary Control is for boundary location is a textbook. It's not a law book, so they can't mandate anything, but it's interesting that as I was going through this, I saw this and I thought that it made sense to put it on here so that we can see that there's other references for it out there. And I am aware of other states that require survey reports. So what purpose do surveyor reports serve? Well, first, they explain uncertainties in lines and corners. We've talked a lot in the last few sessions here about how we find what you find out there. You often don't know who said it. We have to see if there's some way of determining what's original, what's not original. And we try to put these pieces together, and it's like a jigsaw puzzle where they don't fit really well. And when we get done and we determine our theory of location, like we talked about in the last session, we're going to see where what we came up with causes uncertainties with other evidence out there. So the survey report allows you to explain uncertainties, just like my friend, the old surveyor, did when he said he had all this stuff in the file. Next, display the basis of your survey. And that is a very simple way of saying theory of location, which we just studied. We can display it there and talk about what we held, talk about what we didn't hold and why. The surveyor report gives you an opportunity to explain the intent of the survey, if the client would allow you to do that. If it's just a simple boundary survey for improvements, you can say so. If there's if it's a survey where it's being done because there's going to be conveyance cut off of a parcel, you can state that too. In fact, there's new rules in Indiana that if you're going to cut a parcel off of an existing parcel, there's a statement you have to add to the legal description. You might want to look that up. It was I don't remember the code number, but it was just put in law, I think in either 2017, I think it was in 2017. You might want to look that up if you're an Indiana surveyor and you haven't heard about that. It allows you to discuss the evidence that you found and the evidence that you set. So I can say that a different way, which is the last bullet. You can say you're describing the footprints that you followed and you're following the footprints that you left to follow. Okay, you can see how a lot of this knits together with everything that we've talked about already, but under a different view. Regarding intent, what is the purpose or intent of the survey? We've talked about that already. Is the survey an original survey or is it a new parcel? Or I'm sorry, let me rephrase that. Is this an original survey as in a new parcel? That's really important to put there. Someone might be able to figure that out over time, but I put, and we'll see where I'm going to talk about what I typically put in a surveyor report. I state if it's an original survey or a retracement survey. And again, I don't get into personal things as to why maybe I don't want to say they're fighting here and I'm going to determine who's right and who's wrong, because I don't do that anyways. We just show them evidence, but it's important to know that it's an original survey. Then you know that those monuments that we said, if it's original, those monuments, that's the parcel. Those are the monuments. Those are the corners. Is it a retracement survey? And from there, that leads to more questions. Was the survey cut out of something? Was it just a retracement because somebody else did the same parcel when it was first cut and all this stuff? And so there's a lot of questions that may lead to, but it's very important to know if we have an original or a retracement. And then lastly, what is your interpretation of the intent of the original conveyance documents or subsequent conveyance documents, which may affect the parcel being surveyed? We got a lot of different things that we consider and show and explain on survey plats and in survey reports that gives us a good vehicle to use for explanation these days than we did several decades ago. I go back to what I already talked about, a survey plat with 4 lines, 4 circles shown, doesn't say if they're bars, pipes, whatever. Distances, direction, maybe. Distances for sure, maybe not direction. And nothing about adjoiners, nothing about anything else. Maybe shows where the house and the garage or the buildings are at or whatever. Who benefits from surveyor reports? Well, I start with the landowner. And when I'm given something like this live, I often have a hand shoot up right away, and there's always going to be somebody in the room, and this is okay, I'm not criticizing them. You're entitled to your own opinion, but they say, I write my surveyor reports so that my client, the landowner, can't understand them. And if I wanted to engage in this, and I do sometimes, especially if I see a lot of people looking at me with shrugged shoulders saying, aren't you going to do something about this? And I don't want to fight, but I want to discuss, and I'll say, why? Who's paying the bill? You know, who deserves the benefits more than anybody else but the landowner that you're doing the survey for? So I try to word them so that the landowner does. And I can't think of one time where a landowner called and said, I don't know why you wrote this. Can you explain to me what this is? They usually probably don't read it anyways, but still. Retracing surveyors. That's a good one. That's a really important one. Whoever's going to follow your footsteps, you're giving them footsteps to follow, and the surveyor report aids in that. Title companies, especially with ALTA surveys. And you say, well, wait a minute, this is an Indiana rule. Why would you put this on an ALTA survey? Because it's a boundary survey. An ALTA survey is a boundary survey. And in Indiana, if you do an ALTA, a full ALTA, and you're doing the boundary survey there, you have to also comply with Rule 12. And so we put surveyor reports on ALTA surveys. And I think the title companies get a lot of good information out of that if you do it right and you word things in a way that's understandable and to the point. Attorneys. Attorneys don't always see your surveys. They don't see every survey that somebody does, but they certainly will see a survey if they're involved in a transaction or if they're involved in a dispute or whatever. and I think it'd be valuable for them too. Many attorneys that get involved in lawsuits relative to boundary lines and encroachments and things like that aren't really versed in land law and what surveyors really do. And so it might help to have that surveyor report them to see the wording of what the drawing means. Lenders, oftentimes the lenders will get see some things there that they think they might need to be concerned about, and work with the title company to make sure that they get that resolved. The courts, if you happen to have to go to court, and we hope we don't have to go to court, but the surveyor report, I think, will be very valuable for the judge to see and for opposing attorneys also. And then I put the surveyor who completed the survey. Now that's put there last, and I don't mean these to be in descending order or anything, but I can't tell you how many times, and if I'm the only one in the room, so to say, we're kind of in a room here, if I'm the only one in the room that has ever gone and remembered that I did a survey in an area, or I think I surveyed this parcel already, and I pull it out of there and I set it on the desk and I sit down to look at it and see what I got. I look at it, I've looked at some before and say, why did I do what I did here? What made me choose this solution? And I can't remember. And it either reminds me and I'm happy about it, or it reminds me and I figure, I don't know that I would do that again. I think we all grow, and it comes from the decisions that we make, okay? And the decisions that we get questioned on. And when we also grow by seeing what other surveyors do. We just looked at who benefits from the survey report, and I'll just put these down here because I go through the same list again for who are the survey reports written to. And I think I probably covered everything relative to what we would say on this slide in what we talked about already in the last slide. So to refrain from being redundant and stay on time here, I'll move on. What format, if any, is required? I told you I liked POB magazines, funny things they put in there. And they got a Dr. Seuss thing here, survey report, track 1, track 2, tract old, track new, which tract is Smith, which tract is Sawyer's, I don't know, go ask a lawyer. So, and it's titled a survey report. So somebody, and I don't have the copyright on this one, but somebody submitted this to POB back, it had to be back in the 90s, I think, when they did a lot of these. But we're going to talk about format here. When I start talking to somebody about the format of a surveyor report, I go right back to the rule. And this is the guts of the rule right here. And what I've bolded to me is the guts of what you need to pull out of here and put into the format you want to use. When conducting a retracement survey or an original survey, a registered land surveyor shall do the following. Furnish the client with a written surveyor's report that, first, in addition to other pertinent data, so there's going to be other pertinent data that you're going to have to talk about here, so you're going to want to remember what that might be, explains the theory of location applied in establishing or retracing the lines and corners of the surveyed parcel, and gives the registered land surveyor's professional opinion of the cause and the amount of uncertainty in those lines and corners based on the following. And then we go through availability and condition of reference monuments, occupation or possession lines, clarity or ambiguity of the record description used, adjoiner's descriptions or both, and the theoretical uncertainty of the measurements. And we'll talk about theoretical uncertainty. It's very akin to the relative positional accuracy. And this is an old rule here, by the way. I shouldn't have put theoretical uncertainty here. I apologize for that. This is an old slide. It's relative positional accuracy in Indiana now, the relative positional accuracy of measurements. So make a correction to that. I apologize for that. I hope I don't have that throughout this particular presentation. Relative to availability and condition of referenced monuments, we got a principle that's in numerous textbooks that says either this exactly or something very close. In order to be controlling, a monument must be called for in the writings It must be identifiable and it must be undisturbed. Called for in the writings, identifiable and undisturbed. If you don't have all three of those, you don't have a controlling monument. That's why we don't just draw a circle on the plat and not describe what the monument is. There's a principle that goes along with this out of the evidence and procedures text that says an original monument found undisturbed usually expresses the intent of the parties to the conveyance, fixes that point as between the parties, and as such has no error in position. All restored monuments established by measurements have some error in position. So can we tie these two principles together? If you're calling it an original monument, then you're saying it's been deemed original, so it is controlling. So that now ties directly into what is up above there. In order to be controlling, that means you've determined it as an original monument. The monument must be called for in the writings, identifiable and undisturbed. And then it gives you here what an original monument means. Availability and condition reference monuments, sticking with that. We could talk about monuments for a whole seminar. There's a principle from Boundary Control and Legal Principles that says monuments called for in a deed, either directly or by survey or by reference to a plat that the parties relied on, are subordinate to senior rights, clearly stated contrary intentions, and original lines actually marked and surveyed, but are presumed superior to direction, distance, and area. And then I've got a statement down here that's just a quote. It's not a principle, but it comes from Boundary Control and Legal Principles. And it says that many surveyors are guilty of using non-specific terms such as stake, post, staff, or IP, probably meaning iron pipe or iron pin. You're not sure which one it is. To eliminate future conflict, it is imperative that each monument be identified as to its exact nature, including size, material, and identifying marks. We'll talk more about this as we move on forward here. And then we have the order of importance of conflicting title elements. And if you took classes on survey law, you undoubtedly came across this. And if you haven't taken them, you probably ran across it anyways, because we refer to this so often. This one is basically taken from Boundary Control and Legal Principles, and this is right out of the last most recent edition, the 7th edition. And I'm going to go through this, and because we're going to talk about some of these things as we go through our terminology and relevance to the surveyor report here. We start with A and B, which are two elements that the surveyor really doesn't have a whole lot of control over. The first is the right of possession or an unwritten conveyance, unwritten rights. And if you know your survey law and your property law, that every state has a statute of limitations and a bunch of requirements that are necessary in order for somebody who occupies somebody else's land to rightly at some point gain title to that land by an unwritten conveyance. That's adverse possession, and the other types of recognition and acquiescence and things like that. Then you have senior rights, and that's in the event of an overlap. That's if you got a 100-foot parcel and you divide it in such a way and you think you're supposed to have two 50-foot parcels, but the geometry doesn't give you 50-foot widths and you got an overlap, then the first one, if it's not subdivided, the first deed in, typically in most states, gets their 50 feet, then the other one gets the remainder. Okay, and that's something else that a survey really can't do anything about. When typically what we focus on, and possession is going to come into your report, senior rights may come into your report, but we've typically focused on the written intentions of the party. We have call for a survey or an actual survey on which the conveyance is based. And that's a very strong call. What the text says and what the law says is that if you call for a survey, and it's the survey that the survey was actually based on, everything that's on that plat is basically just interjected into your plat, okay? Even though it says lot 5, block 10, If you got the plat that created that, or if it's, you know, some parcel that was taken out of another parcel, the original survey of that other parcel even is brought in. Okay. Calls for monuments, and natural typically take precedence over artificial, because natural is set by nature, not by man. Artificial is set by man. And so man makes mistakes. And so typically the courts will lean towards the natural monument if it's in conflict with an artificial monument. Calls for adjoiners. That's, some people say, well, the adjoiner is also a monument. It's a legal monument or a record monument of sorts. And this isn't the only list of title elements in the order to follow. And sometimes they mix these up a little bit. And these authors even say that we shouldn't treat this as the only list of conflicting title elements, that, and we might even, in certain jurisdictions, look at this and pull adjoiners up ahead of monuments, depending on how the parcels work together. Call for direction and distance. That's when they're called together and either are controlled by something or they control themselves, or call for direction or distance. You might have the way a call is that the direction controls the direction of the line, the stated direction, and the distance is controlled by what line you end up on, or vice versa. You can also have the distance controlling in the direction. I'm sorry, the distance being subordinate to something else and the direction being controlling. And then call for area, and that's typically referring to, you know, a legal description that says the north 10 acres of the following. Whatever you do, that parcel, the intent is 10 acres. So that's the kind of situation where the area would be way up at the top. This is where it's done as an addendum. You know, you describe everything and then you say kind of like, oh, by the way, it contains 4.59 acres more or less. Okay, that's all the way down at the bottom. That's a product of all the dimensions. Okay, occupation and possession lines. We got some principles here. Possession may memorialize original survey lines, and as such may be the best or worst evidence of original lines. That comes from Evidence and Procedures. Because original lines surveyed and marked by the creating surveyor control over other elements in a deed, the surveyor must determine whether the line of possession recovered is the best remaining evidence of the original line marked. And then it says any unwritten right of or possession that ripens into a fee right extinguishes prior title rights. And normally, and we should know this as surveyors, a surveyor in the United States does not decide who has unwritten rights. He or she merely notes the evidence of encroachments and evidence of other surveys. The final decision is a legal one that is made by the courts. And we better make sure that if there's an encroachment possible, we show it on our plat, because we can be drawn into that if there was an encroachment and we didn't show it on the plat. Getting back to our friend Cooley, who we've cited in most of these sessions here, occupation, especially if long continued, often affords very satisfactory evidence of the original boundary when no other is attainable. And the surveyor should inquire when it originated, how and why the lines were then located as they were, and whether a claim of title has always accompanied the possession, and give all the facts due force of evidence. Unfortunately, it is known that surveyors sometimes, and he wrote this back in the 1880s, so but we can still probably find surveyors that fall privy to this today too. The surveyor sometimes, in supposed obedience to the state statutes, disregards all evidences of occupation and claim of titles, and they plunge whole neighborhoods into quarrels and litigation by assuming to establish corners at points with which the previous occupation cannot harmonize. And I again refer to you who have been in the past 3 sessions. This relates to my survey that I keep referring to with the infamous PK nail at the proportional north quarter corner. It's this statement here from Cooley that really helped lead me to the decision that I came up with relative to what I was going to hold for that survey. As far as clarity or ambiguity in record descriptions, there's principles here too. When establishing the boundaries of a property in accordance with a written deed, the boundaries must be established in accordance with the written terms of the deed. Parole evidence may not be taken to determine the terms of a deed, but may be used only to explain ambiguous terms of a deed. And of course, parole evidence is verbal testimony from other landowners or other people you come in contact that may know something about what's out there. And we have another principle that says that when a conveyance is reduced to writing, it is assumed to contain all the terms intended and is construed, if possible, to give effect to all the terms. The parcel is only, or the boundary and the surveyor's fortune in being able to understand it is only as good as the way that the description was written. I have when I do legal descriptions class or a legal description seminar, I have a very short statement that I usually put on the first slide of a PowerPoint for legal descriptions. And it says, yesterday's land descriptions are the source of today's boundary problems. So you can probably agree with that. And then we get into relative positional accuracy. This is akin to the relative positional precision in the ALTA standards. It's really the same thing. Indiana has more classes to look at for the types of surveys and the way that the property is used, but ALTA surveys has just the most stringent. And this is statistically based. If you've done anything with statistics, you understand the bell curve. If we're looking at this, and if this line in the middle where it says frequency of occurrence, if we're measuring error here, this is zero error, and then this would be positive error on the right side. This would be negative error on the left side, and the number of occurrences of the error comes up here. And so you can see that if we have a perfect set of data that we look for error, which we would never have, but nevertheless to describe this, the area, I should say, under this part of the curve on the right side, using the curve and then the horizontal line, is going to be equal to the negative side. The pluses and the minuses appear to be equal to each other. That'd be in a perfect set of data, okay? And you could also say that we have a higher probability that we're going to have less error in a survey or in a set of data than we're going to have more error. Okay, and that's true on either side, positive or negative. Relative positional accuracy means the value expressed in feet or meters that represents the uncertainty due to random errors in measurements in the location of any point on a survey relative to any point on the same survey with 95% confidence. And this is the same, you'll see the same definition in the ALTA standards. Measurements for retracement surveys relative to Rule 12. It says the purpose of this section is to prescribe precision and accuracy standards to be used by a land surveyor in conducting original and retracement surveys and route surveys. The land surveyor shall select the appropriate equipment and methods and use trained personnel to assure that the acceptable relative positional accuracy specified in this section is not exceeded. Continuing, it says the degree of precision and accuracy necessary for a survey shall be based upon the intended use of the real estate. If the client does not provide information regarding the intended use, the classification of the survey shall be based on the current use of the real estate. And that's going by zoning primarily, the type of zone that you would think with the type of use that you observe while you're there. And the classifications that they have are, first we got the urban surveys, which are performed on land lying within or contiguous to a city or town for single-family resident, except for single-family residential lots. And urban surveys include commercial or industrial properties, condos, townhouses, apartments, and other multi-unit developments, regardless of geographic location. We have suburban surveys, which basically are residential subdivision lots. Surveys of single-family residential lots shall be suburban, even if the lot is located in an urban area. It's use-based. And then you have rural surveys, which are performed on real estate lying in rural areas that does not otherwise meet the definition of either urban or suburban. And then we have our statements of measurement. There's 3 of them. For the urban survey, we have the same one that's in the ALTA standards, plus or minus 0.07 feet or 21 millimeters plus 50 parts per million. Suburban surveys would be plus or minus 0.13 feet or 40 millimeters plus 100 parts per million. And then the rural survey would be plus or minus 0.26 feet or 79 millimeters plus 200 parts per million. And again, the relative positional accuracy is identical in definition, other than the different types or classifications, if you will, to what's described in the ALTA standards, but the word precision is used there. And I said this in one of the previous sessions that whenever the opportunity is right to be able to go in and change statute law, from what I understand, that those that in the state society in Indiana that work with this, that's going to happen. They want the word accuracy taken out here and precision put in it. With our discussions in the previous session on accuracy and precision, I think you would agree. Relative positional accuracy may be tested by comparing the relative location of points in a survey as measured by an independent survey of higher accuracy, or by the results of a minimally constrained, correctly weighted least squares adjustment of the survey. And again, that's all verbatim too, from what's, or pretty close to verbatim at least, to what's in the ALTA standards. And here's a suggested outline. This is something that I typically would work with, and this is a basic order that I have for my surveyor report. I do state if it's an original survey or a retracement survey, and generally we don't need any more explanation other than that about the type of survey. I do explain survey intent if it's needed, and if it's allowed by the client. I do explain the theory of location. I try to put it in as understandable as words as possible without using survey jargon. And I try to talk about uncertainties that might exist. And just the way the past session that we had on theory of location says to do it. What we want to do is let them know where there's uncertainties that need to be talked about or need to be concerned with. I list documents and old survey plats of reference, anything that we used for the survey, monument availability and the uncertainty of those monuments that we show. We don't just show the ones we held, we show the ones we didn't hold too. We show occupation lines, and where it's feasible, we dimension it to the parcel lines that we've determined are what we're holding for the survey. And this might be a little old-fashioned, but I don't use the word encroach. I think encroach means it has more to do with land rights than it does where improvements are built. And so I just say that the fence is 3 feet more or less west of the line, appears to be 3 feet more or less west of the line. I put general statements like that. The clarity or ambiguity of record descriptions. If you're going to have, you got parcels out there where record deeds don't come together. They have gaps or they overlap, and you got problems there. And the surveyor should do enough study of this to make sure that they can clearly say, with as much certainty as they can possibly get from reading legal descriptions, whether there is certainly an overlap or a gap, or there appears that there might be an overlap or a gap. You can word it to however comfortable you are with what you had from the quality of the descriptions you work with. And then we work with the relative positional accuracy of measurements, make a statement very simple to that. Usually state what class survey it is, and I usually just state that the uncertainties were within the range of the relative positional accuracy for an urban survey, which is plus or minus this or that. Those are very forgiving, by the way, I think, plus or minuses. If I can skip back a couple, these statements here, the urban survey, suburban survey, and rural surveys, these formulas that they have here, if you figure those out for the amount of measuring that you do, they're very forgiving with what you have. And then I have other notes. I refer to a title commitment. I state if I was given a title commitment, I say who the title company was and what the commitment number was. If I didn't get a title commitment, I certainly state on there that a title commitment was not provided for use on this survey. There could be information in there that I don't have. We certainly state the basis of bearings, and we do a lot of GPS. We still do surveys and maybe rotate a parcel if you've got a lot of parcels around it that are on a common basis of bearings, and we call that assumed. or if, you know, it's just, every survey is different, but we try not to put a piece of a puzzle that's rotated in a fashion to what's around it. And then we summarize the survey methods that we used. Did we have open traverse, total station, GPS, and all that is what I talked about. So coming back to here, I got a couple of very short statements because we're almost out of time here, but a couple of short statements that for my favorite survey here of the day, since I think I've mentioned this in 3 of the 4 sessions. And when we came to the decision to hold the PK nail at the proportional corner there and ignore where the actual quarter corner, we thought we had enough evidence to put it there, but so much development took place in order to, after I should say, that PK nail was set and held that, because the county surveyor, since he said it, he put that in the indexes, that's the corner. And there was so much that took place on both sides of this north section line that it would have been like what we saw with Cooley a few slides back. We would have been throwing neighborhoods into constant litigation. We are moving our parcel, so it pushed somebody else one way or the other. It would cause gaps on one side, overlaps on the other, and it could have a ripple effect of all that. So to keep peace in the neighborhood, if you will, we held that, but we held that proportional point. But it was very fortunate that we had to write a surveyor's report, because I was able to explain why we held that proportional point, even though we had evidence that the quarter corner was located a certain amount north and west, I think it was, of the proportional, or of the actual corner. And the actual corner also fit with the legal survey that I mentioned. And so we had that on that side too. So without a surveyor report, it would have been a bunch of notes on there that may not have tied together as well. But that is really all I can say about surveyor report, other than all the normal stuff that you would gather that would go in there for a survey like this. So I think we're right on time. That takes us to the end of this, and this is the last of the 4.